The publication by the National Treasury of the policy document, A Safer Financial Sector to Serve South Africa Better. This was a pivotal moment in the regulatory landscape of South Africa. It brought to the fore not only the importance of financial stability, but also the importance of effective regulation of the market conduct of providers of financial services to ultimately ensure a safer environment for consumers of such services. Now, the FAIS Act focuses on market conduct regulation, and this was the first of its kind in South Africa. This happened when it was promulgated in 2002. However, due to ever-changing market practices and new innovations, it's necessary to update the legislative framework on a continuous basis. To get a bit more information regarding this, we welcome Loraine van Deventer from the Financial Services Board. Now, Loraine is the legal advisor of the FAIS department. We'd like to know from her. Loraine, what significant changes were implemented to the FAIS legislative framework in 2012? This must have been something quite important.
Thank you. The Financial Services Board proposed a number of amendments to the FAIS Act, basically to strengthen the supervision of market conduct, to improve the enforcement capacity of the Registrar of Financial Services Providers, and to strengthen the accounting responsibility of financial services providers when rendering financial services, either directly or through their representatives. As it is imperative that consumers must be furnished with accurate information, we have also proposed prohibitions that basically prohibit any person from performing any act, making any statement or advertisement relating to the rendering of financial services, but as well as to the business of the provider and the financial product involved that is false, misleading, inaccurate, or contrary to the public interest. Now, the amendments were published in the General Financial Services Laws Amendment Bill, and that bill was tabled in Parliament in the latter quarter of last year. Indications at this stage are that the bill will be enacted either during or at the end of the second quarter of this year. The Registrar also made various amendments and updates to exemptions that have general applicability. It further updated the application forms for compliance officers, and more significantly, it developed a specific code of conduct for financial services providers who render services to so-called professional clients.
But I'm sure the big question that everybody's asking is, why make provision for the distinction between different types of clients? Does that make it fair?
It's universally accepted that legislation must not only be efficient and effective, but it must also make economic sense. Now, the Registrar of Financial Service Providers and the FSB subscribes to that. And it recognizes that certain types of client does not necessarily need the same level of protection that is provided in the FAIS Act. Some professional clients may not necessarily want to be subject to the various requirements and sometimes very time-consuming requirements a provider must adhere to before it's actually allowed to render the financial service. We also recognize that the relationship that exists between, for example, an investment bank and its clients fundamentally differs from the relationship that exists between a retail bank and its clients. Professional clients usually act as equals when they transact with a provider, as they possess the same level of understanding of the particular activity or service involved. Or they appoint a number of financial advisors to assist them when undertaking a transaction with a financial services provider, and in doing so they are leveling the playing field where otherwise certain expertise would have been lacking. The code is further in line with internationally accepted principles that legislation should provide for different degrees of protection for different types of clients. And in addition, due to the very nature of the services involved and the type of clients involved and the expertise and level of expertise of the clients, It was agreed that providers should actually, when rendering those services of the financial service to those type of clients, benefit from a code that's more principle-based rather than rules-based. Principle-based legislation is, in certain cases, much more onerous, as it places much more responsibilities on a provider to ensure that it complies with the requirements and and sometimes very widely defined principles.
The big question that most people will probably ask is, what impact will this new code have on financial services providers?
Well, to enable effective monitoring of providers who will be subject to this code, we have created a new category of financial services providers called the Category 5 FSBs. It will not be compulsory for FSBs who are currently rendering financial services to clients who will fall within the ambit of the definition of professional client to obtain the new category or to add the new category to their license, as long as the services they are rendering to those clients then are subject to the General Code of Conduct. Otherwise, if they want to benefit from this new code, they will have to apply for the addition of the new subcategory or of the new category to their license. As regards the competency requirements, it was decided that the registrar will not prescribe the qualifications for both key individuals and representatives, and it was further decided that only key individuals will have to write the level 1 exam, and that neither the key individual nor the representative will be required to write the level 2 exam. So instead of being prescriptive, a Category 4 FSB will have to ensure that it and its representatives have adequate competencies to render a particular financial service in respect of a particular financial product. It is envisaged that this code will be published during basically at the end of the first quarter of this year, but it will only come into operation on a date 6 months after it was published to ensure that people have enough time or sufficient time to actually apply for this new category.
And finally, Loraine, going forward, what will the new focus be?
Confident, informed and empowered consumers are critical for well-functioning markets, and therefore it's imperative that the legislative framework provide for adequate consumer protection. So therefore, going forward, the focus will very much be on ensuring that our current legislative framework adequately protects clients and adequately achieves its objectives, and that we implement the new structures as proposed by the National Treasury effectively.
Loraine, if people want to be in touch with you, where can we get a hold of the FSB and how do people contact you?
They can contact us at 0800 20 20 87 or 0800 11 04 43. They can also send us an email to info@fsb.co.za, or they can access our website at www.fsb.co.za.